Hi. I'm Olivia, a custody advisor at Wall Street Prison Consultants. Today we're going to discuss securities fraud. Federal securities fraud pursuant to 18 U.S.C. Section 1348 is a serious federal fraud that can result in severe legal consequences and can be pursued against individuals, corporations, securities brokers, financial analysts, and even a government agency. The federal securities statute described under 18 U.S.C. Section 1348 is patterned after the mail fraud and wire fraud statutes, and states it's a federal crime to defraud anyone in connection with a security or commodity, or to obtain any money or property from the purchase or sale of security, by using means of false or fraudulent pretenses, representations, or promises. The Securities Exchange Act of 1934 governs trading of stocks and bonds in the United States, and the law was established by the Securities and Exchange Commission (SEC), which is responsible for enforcing the federal securities law. This white-collar crime may also go by the name of investment or stock fraud. The primary element is falsifying or misrepresenting information to influence an investor's decision. Additionally, insider trading involves selling or purchasing stocks on the basis of knowledge inaccessible to the public. Fraud can occur if a trader intentionally offers poor advice, withholds crucial details about a deal, or provides inaccurate information to deceive investors. There must be a connection between the misrepresentation or omission and the purchase or sale of a security. A conviction in a securities fraud case can carry hefty fines and long prison terms. An executive or high-level employee could face accusations of such fraud by selling stocks before the public release of information that could affect a stock price. For example, a scandal may be about to break, or significant corporate developments may soon occur. Others might face charges if someone believes a responsible person disseminated false information to manipulate a stock price. Intent becomes a significant factor in the case. Insider trading occurs when a company employee or associate has some information that is not known by the general public. Then, they use this knowledge to buy or sell a security to make a profit trading on the stock exchange using confidential information. Put simply, it's the illegal practice of trading on the stock exchange to your advantage by use of confidential information. Pump and dump occurs when a broker or investor spreads false information about a security in an effort to get other people to buy it, which in turn will inflate the price, so they can quickly sell it for a profit. Churning occurs when a broker persuades their client to excessively trade in order to generate more fees and commissions. Put simply, churning is a failure to act in the best interest of their clients, for which they are legally obligated as fiduciaries. Misrepresentation occurs when someone attempts to manipulate the value of a security in order to make a profit later by making false statements. Accounting fraud occurs when an accountant intentionally falsifies a company's accounts in order to misrepresent assets and liabilities, which will affect the value of their securities. It is a defense to the federal crime of securities fraud if a defendant honestly and in good faith believed the deceptive statements or promises made as part of the scheme were true. However, a defendant cannot engage in willful blindness by ignoring the truth of the statements. Nor is it a defense if the defendant intends to deceive, but feels the victim will ultimately profit or be unharmed. Commonly called the no-knowledge defense, Section 32A of the Securities Exchange Act of 1934 provides that no person shall be subject to imprisonment for the violation of any securities rule or regulation if the person proves to have no knowledge of such securities rule or regulation. The no-knowledge defense is a unique, post-conviction, affirmative defense, whereby the defendant must prove by a preponderance of the evidence the defendant was unaware of the existence of the SEC rule or regulation that prohibited the illegal conduct constituting the charged securities fraud. Often, law enforcement exceeds the scope of their authority and require people to submit to a vehicle, home, or property search when they otherwise would not be required to, coerce people into agreeing to a search, arrest people without probable cause, or obtain search warrants in bad faith. If any of these can be proven through the filing of a motion to suppress, the courts will suppress the resulting evidence as having been unlawfully obtained in violation of the Fourth Amendment of the United States, which can lead to an outright dismissal of the case, or reduced charges. A federal securities fraud conviction, under 18 U.S.C. Section 1348, is punishable by up to 25 years in a federal prison, 3 years of supervised release, and a fine. 18 U.S.C. Section 1349 states that an attempt, or conspiracy, to commit a securities fraud violation can also be punished in the same way as a violation of 18 U.S.C. Section 1348. Additionally, disgorgement of any profits will be ordered and any property obtained from the proceeds of the offense can be confiscated. Importantly, probation is rarely given in federal cases, and the amount of loss, or aggravating offense characteristics associated with a particular securities fraud